Good morning. Welcome to panel 4 of this wonderful and timely conference about alternative means of fighting the COVID-19 pandemic. My name is Eric Ip. I am an associate professor of law and the deputy director of the Center for Medical Ethics and Law at Hong Kong University. This panel is made up of 3 presentations, each 15 minutes. To be followed by a questions and answers session. I will remind speakers about the time as we've slightly overrun a bit. So let's get started. I'm pleased to introduce our first speaker, Professor Jorge Contreras, presidential scholar, professor of law and director of the program on intellectual property law and policy at the University of Utah, to discuss with us the Open COVID Pledge as a model for public interest utilization of IP in the coming 15 minutes. Professor Contreras, please.
Eric, thank you very much. I'll just share my screen here. Hopefully everybody sees that. Great, so thanks very much for this invitation. This talk is really just to describe a project that I and others were involved in during the COVID-19 pandemic to make intellectual property in some areas more broadly available. The project was inspired by early news reports that began to come out in early 2020 as the pandemic began to emerge around the world about potential intellectual property blockades that were preventing the manufacture, distribution, and dissemination of primarily equipment and diagnostics relating to COVID-19. You probably remember the prominent stories about ventilator parts shortages, could not be 3D printed, lawsuits relating to diagnostic tests, and so forth. So as these news reports began to emerge, academics were beginning to do studies about the patent coverage of certain critical technologies in the beginning of the pandemic, and Frank Tietze and his group at Cambridge University began to realize that there are an awful lot of patents that are relevant to these technologies that are directly relevant to the response to a pandemic. And so, as we know, and certainly as we've heard during this conference, there are numerous IP-type responses to a pandemic situation. Compulsory licensing, of course, which did occur early in the pandemic. Pooling efforts, which, again, WHO and others have been active in. Unilateral pledges of technology made by IP holders. This happened early in the pandemic, particularly by ventilator manufacturers, but also a couple of drug companies, and Moderna, the vaccine producer, which this came in October of 2020, and also communities of affiliated organizations making pledges of their IP, primarily in the university context. And then the one that I will talk about is the Open COVID Pledge, which was one of these collective pledge activities. So in March of 2020, a group of 10 of us and a number of others who were less involved got together to try to figure out how one might create a platform for enabling technology sharing on a broad basis in the face of such an emergency. The goals of this project were to create a framework, legal framework for contributing IP. We wanted it to have a number of attributes, particularly we wanted it to be lightweight and self-executing, that is, not a complex negotiated set of agreements, something modeled on open software or open source code licensing and the Creative Commons suite of open content licenses. We did not want to include things like trademarks, trade secrets, or technology transfer explicitly, simply because those are far more difficult to license and transfer. Limiting this to patents and copyrights, which is what we did, is quite self-executing. It basically provides a legal basis and a freedom of action against legal impediments, but does not necessarily enable actual production. We understood that. This was one of the many trade-offs that we discussed and made in this project. We also wanted it to be something that could be very broadly adopted, both by IP holders and by users. So we didn't want to impose terms that were going to be onerous on either one of these groups. And so what we came up with is something called the Open COVID Pledge. It was released in April of 2020. The pledge itself is basically one sentence long, a commitment to make IP available free of charge for use in ending the pandemic and minimizing its impact. Of course, these sorts of broad aspirational statements are often lacking in legal enforceability. And so just like open source code licenses and the Creative Commons licenses, we created a more robust license agreement that is, again, self-executing. Anyone can opt to abide by it by taking advantage of the rights that are offered. The scope of the license is limited only to the COVID-19 pandemic. The duration of the license is limited to the pandemic plus a 1-year ramp down period. There are a couple of other tweaks that we included to attract both pledgeors and users. One is the regulatory exclusivity. As again, we've heard and most of you know, patents and IP are not the only source of exclusivity in this area. The FDA and other medicines regulatory agencies provide market exclusivity, and this commitment would waive that exclusivity as well. And we also included a defensive suspension provision, quite common in many types of patent licenses, that says that if you pledge your IP for public use, but then one of the users sues you on patent infringement, your license to them is suspended. This makes patent holders and other IP holders feel more secure that they're not giving away IP that they hold for defensive purposes. So the adoption of this framework was fairly encouraging, and it came from a variety of sectors, primarily the high-tech sector with large enterprises like Facebook, Amazon, Intel, IBM, Microsoft, Hewlett-Packard, and others signing on, but also some small and medium enterprises, 2 US national laboratories, Sandia and the NASA Jet Propulsion Laboratory, 1 university, and a couple of coalitions, basically university and academic based coalitions of groups, one relating to the creation of open source ventilators for use in the developing world, and the somewhat controversial RADVAC initiative, which promoted the sort of self-testing of vaccine technology. So it's difficult to estimate numbers of patents and patent portfolios, but we estimated that something like 500,000 patents were contributed to the effort through this mechanism. And so how do we think about what actually happened in retrospect? So Titsa and others in another paper classified the types of products relevant to a pandemic or other public health crisis. They call it crisis critical IP. And if you look at these 5 product categories, biopharma products, diagnostics, equipment, PPE, and digital innovation, there is a wide variance in how products and IP in these different categories were pledged, both through the Open COVID Pledge and through the Open COVID Pledge, plus other unilateral pledges. And you can see there's sort of a spectrum effect here. with not surprisingly pledges in the biopharma area being the lowest and in the digital space being the highest. So just to give you a little bit of an idea of what's going on here, in looking at the pledge technology, digital innovation is actually quite important in many areas, both in actual drug development and analysis, disease modeling technology, but also in more mundane applications like routing for emergency vehicles and particularly supply chains. Contact tracing is an area that I'll come back to, in which there was significant pledging activity. And then even a highly controversial area around social media and misinformation. Some techniques and algorithms around this are patented and contributed by pledgors like Facebook. In the area of PPE, the national laboratories actually have a significant amount of intellectual property, as well as some small companies, and this is all made available for free to the public. Medical equipment and devices, which is where much of this controversy began in the area of ventilators. Small enterprises that had created readily 3D printable either testing devices or devices for hospital use, made those available. Ventilators, though this is the Open Ventilator System Initiative, which I mentioned earlier, which is working on a portable ventilator for use primarily in the developing world, was part of the pledge. And then, of course, Medtronic and Smiths Group, major worldwide ventilator manufacturers, voluntarily pledged their technology for certain ventilator models without charge. So medical devices have fairly good coverage. Diagnostics, again, the diagnostics area is one area that got early prominence when a large patent assertion entity sued the maker of one of the first COVID-19 test kits. There is a fair amount of IP relating to diagnostics held by a surprising number of entities. You wouldn't think, and I didn't think, that IBM or Intel or these companies had significant diagnostic related IP, but they do, as it turns out, as do the national labs, both on the highly technical side, but also in terms of things like designs for drive-up testing booths. Again, those who know the patent world know that designs like this, if they have some utilitarian function, can indeed be patented, and they are. And then, of course, in the aftermath of the litigation that I mentioned, the patent assertion entity holding about 800 patents that it obtained from the defunct Theranos diagnostic company did pledge those as well. Finally, in the biopharma area, as I mentioned, RadVac was part of the pledge, and companies like IBM, again, with one of the largest portfolios in the world, lo and behold, does have some antiviral technology. But the most important pledges in the biopharma area, of course, were unilateral pledges made by University of California, Berkeley's Innovative Genomics Institute. These are the people, of course, who are involved in CRISPR discovery. Kaletra, the drug made by the pharmaceutical company AbbVie, and of course Moderna's mRNA vaccine technology, which it voluntarily pledged in October of 2020. So one might ask, what is the benefit of these types of pledges, especially if a field is not 100% covered by pledges? And our theory is that pledges can clear the field of patent risk, making fields characterized by reduced assertion or litigation, right? These are fields that you can look at and say, yeah, there's not a huge amount of patent litigation going on in this field. So maybe it's safer to innovate in that field. I don't have to worry that I'm going to be sued by Microsoft or Facebook or Uber or Fujitsu or some other large patent holder, creating something of a knowledge commons and an open innovation ecosystem. Basically, it is a signaling exercise that a particular field is open to user innovation. And we have seen this, of course, the model for this is open source code software, in which there's a huge amount of innovation over the years, and open source code was supported in its early days by pledges by companies like IBM and Sun Microsystems and Google not to assert patents against open source programs like the Linux operating system. In the COVID area, we've seen things like contact tracing for, again, whatever you think about the privacy issues around contact tracing, it is something that is used, and there was not patent or much litigation around it at all. Same thing in many of these other areas. So whatever may happen in the area of vaccines and therapies, again, which is, I think, a somewhat different area, in these areas, the voluntary pledging activity by large IP holders has, we think, led to some beneficial results. We've done a lot of writing, and other research groups around the world have started to analyze what's gone on here. There's an extensive paper that was just released this week in the Utah Law Review that I recommend to you if you're interested in the design and design choices that we made in bringing the open COVID pledge out. Choices and lessons that we hope will be useful to those who are planning similar frameworks for the next public health emergency. So thank you very much for your time. I look forward to the Q&A.
Thank you very much, Professor Contreras, for your insightful presentation and for keeping the time limit perfectly. Our next paper, New Licensing Avenues to Promote Public Health, will be presented by Professor Anna Santos Rutschman, Assistant Professor of Law at St. Louis University, and Professor Sapna Kumar, Professor of Law, John Mixon Chair, and Co-Director for the Institute for Intellectual Property and Information Law at the University of Houston. Professors Rutschman and Kumar, 15 minutes, please.
Thank you so much. And thank you, Professors Sun and Sunder, for organizing this outstanding conference. Drug scarcity has impacted all countries, both high income and low, during the pandemic. And much attention's been given to the TRIPS IP waiver, to the EU counterproposal for expanding compulsory licensing. But there's still questions that remain about what we can do to reduce problems during future pandemics. And several earlier speakers have addressed pieces of this. Professor Kapczynski talked about utilizing government leverage over pharmaceutical companies. Professors Lee, Rai, and Price all talked about the importance of know-how and tacit knowledge to quickly replicating and scaling up drug production. And so the question that my co-author, Professor Rutschman, and myself are addressing is, how do we increase this government leverage to get those pharmaceutical companies to share know-how and tacit knowledge? And so we're arguing that contractual provisions can serve an important role in ameliorating drug scarcity by facilitating transfer of technology and know-how, and doing so ideally in advance of a pandemic. So just to give us brief structure for the talk, I'm going to very briefly discuss limitations in current solutions and introduce the idea of using contractual language when the government provides pandemic-specific funds for drug development. And then I'll turn things over to Professor Rutschman to speak about dormant licensing clauses and using it more broadly. So the current solutions, due to the nature of the pandemic, have been focused on post hoc solutions, both with the TRIPS IP waiver and with the European Union counterproposal on expanding compulsory licensing. And several people have already spoken about the problems with regard to sharing of know-how and being able to quickly replicate complicated drugs. And the thing I'd like to add on to what has already been said is also the inertia problem as well, that governments have to decide when to act And those delays cost lives. Those delays in figuring out, well, is now the time that we grant a compulsory license? Is now, a sufficient point in the crisis that we need to, mobilize? So how do we shift that planning to earlier on? How can the government avoid these situations of scarcity, or at least address them more quickly? So while it isn't a complete solution, we think that research funding contracts should be part of the solution. And one way to do this would be to increase requirements with regard to drug availability when there is pandemic-specific funding. So the United States, UK, European Union, and several of its member states all spent money funding private companies' vaccine development. But these governments asked for very little in return. There were various carve-outs in the United States agreements, even for what's required under the Bayh-Dole Act. And generally speaking, we didn't see a whole lot of effort from the Trump administration with regard to putting in promises of availability of pricing or the like. So one thing that could happen is to make pandemic-related funding contingent on drug companies producing a sufficient quantity of the drugs. What we could do is require companies to license out their technology in the event of scarcity to a suitable third-party manufacturer. We could have a grace period initially, and then after that grace period, there would be an automatic requirement to license out technology. And in the contractual provisions, the government could hammer out what a predetermined royalty would be in the situation of scarcity, we could base this off the expected sale price for the relevant drug. And the government could still retain other rights. Like, this wouldn't be a substitute for margin rights under the Bayh-Dole Act, but an additional power. In terms of how this would be enforced, penalties could be used for failing to cooperate or failing to hand over know-how. At minimum, there could be steep financial penalties in the event of non-cooperation. And with regard to the scope, at the very least, countries could use this to avoid scarcity in their own country, in their own borders. But ideally, this would be used more broadly to secure promises with regard to availability in low-income countries, with regard to pricing even in low-income countries. Now, it's important to note this approach with tying it to pandemic-specific funding has weaknesses. At the very least, there's going to be a much higher cost for the government to secure this kind of promise on the brink or during a pandemic. There's going to be, a timing issue in terms of the government's bargaining position is going to be weaker because, companies like Pfizer will say, well, we could just refuse this funding and not have our hands tied. And so a better way to do this than just tying it to pandemic specific funding would be to get assurances at the, before there's an outbreak, when the initial research is funded. And so at that, I'm going to turn things over to my co-author, Professor Rutschman, to talk about dormant licensing.
Thank you, Professor Kumar. And I'll start by interjecting my thanks to the organizers and participants in attendance at this conference, where we've learned so much. And building from that, I will say that one of the things we would like to emphasize is that the things we're proposing today, both what Professor Kumar covered and now what I will cover, dormant licenses, are possible cumulative interventions with many of the things that have been discussed today and that are on the table, including things like a possible waiver, which some of us have been very critical of, but we just want to reiterate this cumulative nature of the proposals we're making here. And we want to also highlight the importance of addressing this mismatch that we see sometimes between the interventions that are available to us, which tend to be all ex post once there's a public health crisis already undergoing, and the need for preparedness in a broader sense. So we're trying to come up with different types of ex ante interventions, and we're also trying to conceive of those interventions in a context that, from a legal perspective, gives us binding frameworks we can quickly turn to should a pandemic or epidemic or other form of public health crisis really occur. So in addressing now our proposal for a dormant license, or really, I think, a set of tailorable dormant licenses that we could avail ourselves of in order to better prepare, legally speaking, for the challenges of tech transfer during a pandemic or epidemic. We're really trying to think of an intervention that's not really subject to the temporal, resource, and bargaining pressures of tech transfer during public health crises like COVID-19. So here's what we mean by a dormant license. It's not a new figure to the literature or practice. We're really thinking about a pre-negotiated contractual framework, which would become active if and when an identifiable event occurs. And for us, the identifiable event will be the public health crisis, or the type of public health crisis we're trying to address and make tech transfer easier during that particular crisis. And we're thinking that the trigger event has to be formally declared by an appropriate public health oriented institution. Names that come to mind and institutions that come to mind would include the World Health Organization, but nothing would prevent the policymakers devising this structure to name a different institution. But we think there's got to be a trigger, and one that is formally identifiable. And once that trigger occurs, so should you follow our solution or our proposal, we would be thinking of the formal declaration of a pandemic or public health crisis by the World Health Organization with regard to COVID-19. That was in March of last year. So once that formal declaration occurs, then the pre-negotiated contractual framework would be then used, would become active, and impose tech transfer obligations on the licensee that would extend throughout the duration of the formally recognized public health crisis. So this would be negotiated ex ante, would become active during the pandemic or epidemic. And in addition to these very broad features that really borrow from existing pre-negotiated contractual frameworks we've looked at, there's a couple of additional features we propose that Professor Kumar in a different setting has already alluded to, but I'm going to highlight what we think would make sense in the context of these dormant licenses we have in mind. So the first one is the establishment of a list of qualifying technologies or components thereof, say a component of a vaccine, like an adjuvant, delivery mechanism, etc. And one of the important things we think that we should highlight here as law professors is that we're not wedded to a particular preset list of technologies. We just want to enable, through a legally binding mechanism, we want to enable policymakers, scientists, the public, or global health community at large to decide at a given point in time what might make sense to negotiate ex ante. And once there's some form of consensus on what should integrate this list, then it can be added on to, it can be amended, it could potentially even be subtracted from, but we think there ought to be a list that very clearly delineates what are the covered technologies. We also think, although this is not necessarily something that must happen in every single case, we also think that the adoption of dormant licenses should be tied to the provision of government funding for medical research. And we would like to emphasize that this also is tailorable, which is part of what we're trying to do here. So governments might decide to allocate part of the funding available for certain types of medical research. And we're imagining that a lot of this would happen in the context of epidemic or pandemic diseases, or R&D in the context of the so-called emerging infectious disease pathogens. And a part of available funding might be tied to these licenses, and a part might not be tied to it, might be free of these strings, of these obligations. But we envision a system in which, from a policymaking perspective, it would be ideal if provision of government funding for at least some areas of medical research would be tied to the adoption of these licenses. Once that happens, we also think that qualifying technologies should be licensed on a non-exclusive basis for the duration of the formally declared crisis. And as Professor Kumar already pointed out in a slightly different context, the funding entities are able, under our proposed model, to consider the incorporation of financial penalties for non-compliance with knowledge transfer provisions. Again, our proposal is tailorable, but we think that funding entities should consider the incorporation of these kinds of provisions. And just to be very clear, so the practical effect of the pre-negotiated contractual framework we are proposing, its practical effect is to suppress temporarily during a pandemic or epidemic the ability of the patent holder to refuse licensure of a qualifying drug or vaccine development component, with potentially, if the policymakers do adopt the penalty that we are proposing, with the attached penalty for failure to do so. And I'll just end by listing the advantages of this proposal. First, as we've pointed out, it's something that's largely negotiated ex ante. It provides legal certainty in the sense that we have a legal framework and we know that there are binding enforceable effects. There's no need to change existing domestic or international legal frameworks in order to accomplish this. We don't get into the geopolitically fraught area of extinguishing or temporarily suspending intellectual property rights. And building on themes that other panelists have addressed of the patent bargain, IP rights holders are compensated under our proposal, which we think is also important. And finally, our proposal is tailorable both in scope. So again, policymakers can choose which diseases or technologies will qualify, and also geographically, because we are thinking of a system in which countries may elect to adopt similar dormant licensing frameworks at the regional level. So it doesn't necessarily have to be a country by country approach. It could be regional. It could be potentially global, should there be the will to do so. Again, this is, we think, an incremental contribution to the legal frameworks available to us to facilitate tech transfer during pandemics. As Professor Kumar mentioned, this is not going to be appealing to all the players in the biopharmaceutical arena, especially the large ones, but many of us had not heard of Moderna before they became a large player in this area. So we're targeting those medium-sized or smaller-sized players. We recognize there are some limitations of the proposal, but we think this would be an important incremental step to consider. Thank you very much for your attention, and we look forward to questions.
Thank you very much, Professors Rutschman and Kumar, for your very interesting presentation. I would turn the session over to Professor Jayashree Watal, former staff at the World Trade Organization Intellectual Property Division and Honorary Professor at National Law University, Delhi, to discuss with us the last paper of this panel, Reducing COVID-19 Vaccine Inequity. Who will implement it? Professor Watal, 15 minutes, please.
Yeah, thanks, Professor Rip. And hello, everyone. Thank you, Georgetown and Hong Kong University, for organizing this fascinating conference in which I've already learned so much, and I look forward to the next session too. So we've heard throughout this conference about vaccine equity, inequity, And we know about the sub-Saharan African countries in particular suffering the worst in terms of the least access to COVID-19 vaccines. But this inequity was actually foreseen as early as January 2020. And we heard from Jorge about how they also looked at it quite early in March 2020. And as far as the international organizations are concerned, the WHO did set up mechanisms such as the ACT Accelerator, and also, which also includes COVAX, with a specific mandate to procure and equitably distribute vaccines globally. So what went wrong? The problem is that the WHO, which is the UN specialized agency for dealing with health, has no real power or authority to control infectious disease. So while it declared the COVID-19 pandemic, perhaps a little later than it should have, that was in March 2020, it really has been helplessly watching since then the stark vaccine inequity play itself out. Its Director General regularly exhorts, shames the G7, the G20, Big Pharma, and all other actors to do more, to donate more, to not administer boosters or pediatric doses until the low-income countries have vaccinated at least priority populations. But all these pleas are falling on deaf ears. And COVAX, whose mandate it is to ensure vaccine equity, and which is fully backed by the World Health Organization, has also been hampered right from the beginning. We have heard this from others also about COVAX, the lack of funding, the shortages of vaccines, the non-cooperation of the supplier manufacturers, as well as the countries. So what is to be done about this? COVAX has not been very effective. And even its initial target was quite unambitious. It was only to cover 20% of the LMIC population by the end of this year. And even that, they're falling a lot short. So we've heard from Calvin Ho yesterday. He's a member of the ACT Accelerator, he told us. And in his presentation, he laid down the problems with the ACT-A in terms of absence of a definitive decision-making body, the governance lacuna he spoke about. And if you recall, I think this stuck in my mind. He said, COVID-19 is everyone's problem, and everyone's problem is no one's problem. So how do you actually overcome this collective action problem or collective inaction? Why are we in this mess that we are in today? And what can we do about it now? So I do believe that the international community, had it acted earlier, would have acted in the interest, it would have attracted the interest of the producers, the vaccine manufacturers, because there was clear economic clout to be exercised. All potential vaccine suppliers were salivating at the prospect of such a large, virtually global, assured market. And in exchange for market access, at least to the low and middle income country markets, collectively, there should have been one global entity in charge of dictating the terms of such market access. This entity, of course, would prioritize vaccine needs vis-a-vis supplies at the global level. But today, it's not the lack, in my view, it's not the lack of finance, not after $650 billion SDR allocation has been made by the IMF on fairly concessional terms for the moment, because interest rates are very low. So everyone has access to this money, including low-income countries, and low-income countries together as a group have about $21 billion at their disposal under the SDR allocation. So it's not lack of finance, nor is it the inadequate global supply of vaccines, because the world is on track to produce 12 billion vaccines. Already, doses, that is. Already 7 billion doses have been administered to date. So it doesn't seem to be the global supply of vaccines, but more the distribution. And so the principal obstacle to achieving vaccine equity is really the lack of a coherent global strategy to do so. And more pertinently, the lack of a credible, effective agency to conceive, manage, and implement such a plan. So my co-author, Ken Shadlin, who's in the next panel, and I have come out with a paper which basically urges the international community to come together to brainstorm on what a global implementation agency should be like, what it should do, what are its main, what is going to be the remit of such an organization, who should be in charge, and so on. Because that's what we need immediately. So there are many questions. And, it's really sad that President Biden, who set up this event on the sidelines of the UN General Assembly in September, didn't really get into this at all. I mean, all that the G7, the G20, the United Nations, they're all at the margins of what is really needed. So there are questions and which require some answers, and it's not us. We are not giving the answers. We're raising the questions, but the community, the international community, has to come together and some of the key players, that is the countries, have to take a lead in this. Those of you who want to know more, of course, can get the draft from either Ken Shadlin or myself. So the first important question is, should it be a new independent intergovernmental entity? I mean, is there an appetite for that? Or should it be a new arrangement under existing international institutions? Because they're going to be tough battles if we look at existing international institutions. Where should it be located, and so on. So logically, it would appear that it should be in the World Health Organization, but not the way it is currently, but an empowered or reformed World Health Organization. I mean, that is on the table, the reforms of the WHO, but can we do this all very quickly? And does the WHO have credibility? At least it doesn't. It seems to lack credibility in certain quarters when, because of its early handling of the pandemic and on the inquiry about the origins of the virus and so on. So we need to think carefully about that. What about COVAX? Yes, it hasn't done well. Maybe there were problems out of its control. How can it be reformed? Can it be reformed at all? Can it be made more effective? Should donor or key suppliers have a say in the final allocations? How should decision-making be reformed? And will the current management be able to accept these changes? What about the Bretton Woods institutions, the IMF and the World Bank? Because of weighted voting in these institutions, it leads to quicker decision-making. It doesn't take very long to make decisions in these bodies. So should it be under the IMF or the World Bank, or jointly under both? And particularly the World Bank, which has field staff, which could be quickly diverted to even deal with the logistics of getting vaccines from tarmacs into arms, as it was put by some. So could that help to make this, just make sure that everything from procurement to getting the vaccine to the arm is done, in one effective institution? What about the multilateral leaders COVID-19 task force led by the heads of the World Bank, IMF, WHO, and WTO? At present, what they do is nudge governments to do the right thing through a data dashboard and some joint statements. Could they do more? And could they take the lead in setting up some such arrangement? What about the G20? The G20 has been offered as a solution by some luminaries, including the DG of World Trade Organization, saying it's the G20 that should take the lead through the global Threats Board, which is really a subordinate board of the Global Threats Council that was suggested earlier. But the G20 has a temporary secretariat brought in by each rotating president country. Each country has a role as president on an annual basis. And how could the G20 really deal effectively with a multi-year lasting pandemic? Now, Larry Summers, who was on a committee with DG Ngozi of WTO, had said that, the G20 dealt very effectively with the financial crisis. Why can't it deal with the pandemic and so on? It's one thing to have a one-time intervention, and it's another thing to have a continuous program of planning, monitoring, implementing, and so on. So we have to think about this. But what about taking up an existing international institution in the global south that works in the interest of low and middle income countries and that could take on this responsibility? So we looked at the new development bank, that is the BRICS bank based in Shanghai, China. Would that be able to effectively deal with correcting vaccine equity in low and middle income countries? We looked at what the work they've done. They've actually disbursed some COVID-related emergency loans. But it's really unclear that the NDB, the new development bank, can rise to this task in the absence of leadership from China. And China, as we know, in recent months has looked inwards more than outside, to take on responsibility internationally has not happened. So then we thought about, what about each region? I mean, we've heard Jerry speak about regional initiatives. So should each region look at this as their responsibility? We've seen the African Vaccine Acquisition Task Team, and they've started they've started procuring vaccines for Africa. We've seen PAHO, that is the Pan American Health Organization, do, and we will probably hear more about this in the next session. But in my view, splitting vaccine procurement by region, although it has the advantage of tailoring demand to specific conditions and needs, it's not going to leave each entity with much bargaining power compared to a global entity. So just look at the African Vaccine Acquisition Task Team. They don't have the bargaining strength that others, that a global institution would have. So we need to think about that. The other questions, of course, if you were to set up such an entity, would be, is it only for procurement and redistribution, pooled procurement as was mentioned earlier, or should it also start at the very early stage of next pandemic, for example, to facilitate R&D and manufacture, regulatory approval of essential products to help with all of this, and to go beyond vaccines to diagnostics, PPE kits, therapeutics, and so on, starting at a very early stage in a future infectious disease pandemic? Should it be temporary? Should it be permanent? Should it have a permanent staff, a core permanent staff? These are all questions that need to be answered. What about leadership? I mean, this is a crucial question. How will it even come about without key governments such as G7 and G20 really taking the lead? And how could they be convinced to take the lead on this? How would we get to a critical mass of low and middle income countries becoming members of such an organization? Because unless we get that critical mass, we're not going to really have effective monopsony power to have bargains in terms of the best prices or quantities and timeliness of supply and so on. So who would fund all of this? So with one of the things that could be done is financial contributions from all the participating governments who are voluntarily participating. How would these financial contributions be assessed? What would be the formula? Obviously, GDP per capita it would be one criteria, but there could be others that have to be thought of. The SDR allocations could be used for LMICs to make their contributions. They could also get grants or loans on concessional terms from donors, from financial institutions. And what would happen after the pandemic is over? Would the balance money be returned to participating governments? The other crucial question is, how do you ensure effective decision-making? So it has to be a small and effective and yet representative decision-making team. How should such a team be structured? Should the largest contributors have the biggest say? How do we get all countries to have a say in decision-making? Should all participating governments have to align themselves with one or the other on the executive team, so to speak? And what about the expertise required? So the requisite technical and commercial expertise in order to identify potential manufacturers, negotiate the legally binding contracts, release grants in time, determine the milestone, monitor and make sure that the milestones are met. Who would do all of this? So there has to be staff and expertise that would be in charge and that would have the expertise to do all of this. Then the other thing is, how would the distribution be done? Would it be according to population, which is the COVAX model, or would it be according to need, which is a dynamic concept to be reviewed regularly? So how would that happen?
Sorry, we've passed the time limit, sorry.
Okay.
Do you want to sum up your argument? Please do so.
So what I'm going to say in the end, actually, one important point I want to just mention is about technology transfer. So many have spoken about technology transfer. Don't you think that a global arrangement would have more clout to decide how to do this, to make sure to put this, to have carrots and sticks, to have some kind of incentives to be given to originator companies to share technologies. So I think whatever we say, we've talked about many ideas. Nothing is going to happen really. And a year later from now, we will still be talking about vaccine inequity, which is the sad reality, unless the international community comes together and thinks of setting up an arrangement. Right at the top, we need an arrangement. And this is really much better than throwing crumbs in donations and just believing that each country should solve its own problems, ignoring the concerns of the rest of the world. So thank you for your attention.
Thank you very much, Professor Watal, for your important presentation. The floor is now open for questions, general comments and reflections on the presentations can also be typed in the Q&A box. Jorge, perhaps, do you have any responses to Houchin's question about why big pharma are reluctant to participate or contribute to the open COVID pledge? And also Kelvin's question about the extent to which patent pledges have been made through ACTA, and to what extent such initiatives are sustainable and could endure beyond the pandemic.
Right. Thank you. Well, I mean, I think the Houchin's question is been answered by many other speakers, of course. I mean, I think it's clearly a financial question. Obviously, there are billions of dollars at stake for the pharmaceutical industry here, and pledging patents, could be seen to jeopardize some of that income. I don't necessarily think that's entirely true. As we know, Moderna pledged its mRNA vaccine patents early on, and it's obviously done fine financially and still has no lack of a market for its mRNA vaccine products. But in general, I mean, we're not surprised that Biopharma is not an active pledger in this area. And I think the more interesting thing is why other companies did pledge their IP, right? And it's because companies obtain and hold patents for different reasons. In the pharmaceutical sector, patents are still obtained for probably their traditional purpose, which is to protect their core markets from competitors. In the information technology, high-tech space, that's really not what patents are used for anymore. Companies accumulate patents for a number of reasons. One reason is to prevent others from patenting technology that they are releasing in their products. Another reason is defensive primarily, so that if another company approaches them with some patent suit, they have something to fight back with. Though those, if you talk to lawyers at big companies, are the major reasons to get patents. Neither of those reasons precludes the companies from making their patents available for things like COVID-19 response. And since these companies aren't primarily in the healthcare business, although of course, more and more tech companies are shifting toward that, they're not cannibalizing a major part of their own expected revenue. So they can be philanthropic in this way, in a way that is productive and helpful for society without sacrificing major revenue components. Now, it's not that we wouldn't be very pleased for the pharmaceutical industry to participate in pledges like this, and we did try at first, but we found that we had zero traction with them, as Jayashree and others have indicated in many of the public programs sort of developed around the biopharma sphere.
Thank you very much, Jorge. Sapna and Anna, do you have any response to Peter's question about how to address potential capacity constraints by patentees during a pandemic in the light of Moderna's claim that it couldn't spare any personnel to engage in widespread tech transfer because of its existing obligations?
First, I should mention that I think the Professor Fisher's and Professor Okeji's solution of apprenticeship type model is one way to overcome a personnel type problem or a time constraint type problem. But I also think when you bake it into the funding agreement, you can obligate them to find the time saying, look, this is what you promised when you took this money, that you would help with technology transfer in the event of a shortage. Professor Rutschman?
I will just add to that. That's what we partly meant by the cumulative nature of the proposal. We're trying to solve the legal infrastructure problem. We think that one of the silver linings of the COVID-19 pandemic is that there will be, and there are ongoing ways to address other types of infrastructural problems, which we think include this idea that we have to have more trained personnel. In the case of our proposal, you have committed, right? You have committed to perform certain duties should the trigger occur. You are performing them here, right, in the United States or wherever you might be located. You're not sending personnel to these areas, but that's the commitment you've now contractually made if you take this this funding. So we bake that into the long-term business plans you might have.
Thank you very much, Anna and Sapna. And finally, for Jayashree, a question from my colleague Kelvin. Do you think a closer collaborative framework involving WHO, WIPO, and WTO, like the WHO OIE FAO framework for One Health, is practicable as a way forward? And if you see any future for the Act A beyond this pandemic?
Yeah, thanks very much, Eric. So yeah, I did see that question on the chat. And there is already a very active trilateral cooperation between WHO, WIPO, and WTO. But for this pandemic, I don't think it's going to work. I mean, it doesn't really help too much because we need others to come on board. And yeah, there's already a very active collaboration going on, as I said. On the second point about Act A, I think, Act A would only be useful even post-pandemic. It would be, of course, very useful, provided it gets its act together in terms of, governance and decision-making, because that is, I think, the major problem with the Act A. And Calvin himself has kind of admitted in his presentation about how that is a problem. So while I have the floor, can I take this other question that's been raised on the chat? on marginalization of the low-income countries and low-middle-income countries by Abby. So I'd just like to say quickly that, if it's an organization for LMICs, and the structure is really made in a way that the LMICs contribute, they have a buy-in because they are contributing financially to this. It is their organization. There's no question of there being any marginalization. So I don't think, I think that can be worked out. But somebody needs to take the lead, and LMICs should really get together and make their market an effective bargaining chip. Thank you.
Right, thank you very much, Professors Contreras, Rutschman, Kumar, and Watal, for today's presentations. There will be no break between this panel and the next. Please stay on for our final panel, panel 5, about an extremely important topic, dynamic protection of public health in China, India, and Latin America. Thank you very much for panel 4 presentations.